All right, people. I think we are live. We are live. Yes. Welcome to another night of pure madness. I'm here with Headless. Headless, let me unmute you. Say hello to the people, Headless. Oh, Headless must Headless. I think your mic might be muted on your end, man. Gotta say hello to the
Oh,
people.
1 second here. Okay, now am I muted?
That's right. That's right. Oh,
Okay, now I'm unmuted. Hey,
you're
people.
unmuted. There you go. I got to put the lamp because the lamp is getting more love
Yeah,
than I am,
yeah.
right?
All hail the lamp.
All hail the lamp. Yes, praise the lamp. So, what's going on, people? How's everybody doing tonight? Right now, it's about 9:21, and you are joining us for the non-sec madness. I'm talking about it is madness. So, yesterday, oh, let me get Spackle in here. We got another guest, the Holy Spackle. Welcome to the show.
Thanks
So,
for having me.
let's. I'm giving the work up to. Let's see what's happening. So first, all right, we all know Kyle filed a motion to set aside the default judgment with prejudice, and he was alleging that the documents weren't served to his address; they were served to his prior address, and that, for some reason, does not was not proper service. So now we've all been waiting for Steve's response. Now, earlier today, did you guys hear red lines like, his video? The letter is so glorious that it will change the world. Did you guys see that? That was like so funny. I watched that.
No, I didn't see that. What was he glorifying the letter for?
He said that he read the document from the lawyers and it was so wonderful that it was, going to change our lives. So I was like excited to see it. But I'm just going to let you guys know this response is pretty bad. I'm just going, well, Spackle, you read it because you sent it to me. You let me know. What did you think about this thing?
I thought it was hilarious because it was like, nuh-uh, that's the last address I knew of. And also, like, here's a whole bunch of other stuff. Like, it just was so dumb. I was just thinking, like, is this real? Like, I thought it was dumb looking. So I sent it to you going, is this as dumb as it looks? Because it was just so hilarious. I don't even know if I should say what I think, actually.
It looks pretty dumb to me. Let's just call it with it. It looks pretty dumb to me. And for the people who like Miss My Lamp, it has its happy birthday thing on it. So that's what the lamp is doing. Happy birthday.
Well, happy birthday, lamp.
That's right. Yeah. The lamp has personality, you know what I'm saying? So it's got happy birthday. It's funny because my daughter's been trying to pull that thing off the lamp for the past hour. But no, that's not for the lamp. I'm like, babe, it's the lamp. That's my thing. The lamp's gotta have some personality. You know how it is. So all right, let me see. I read this. I'm just trying to look at the chat. Anybody? The chat's actually pretty blowing up. 167 people watching this thing. So most people want to see what is good. What does Steve have in response? So one of the biggest issues, obviously, was Steve's admissions. Remember his previous admissions that he knew Kyle moved? You guys remember that, right? Mm-hmm. Steve was saying that he knew Kyle moved and he sent it to his old address, right? So that was clear.
Yeah.
So today, people, we're going to do two things. First, we're going to read Steve's affidavit that he submitted under penalty of perjury about his understanding of the facts. And then we're going to read the motion in the opposition. Now, they also filed two other documents, a couple of order to show causes, but they are honestly irrelevant if the service was poor. So let's first start with looking at Steve's document. And you guys can ask questions or talk along with me. This is not just a monologue. That's why I invited you guys in. So please, if you guys also keep an eye out for the super chats. For those people who understand YouTube and know that this video, like the last video, is going to be demonetized, please bless me with some super chats. I'd really appreciate it. And if you like this type of content, consider subscribing to the channel. Happy birthday, Nate's Lamp from Princess Jamette. Thank you so much. Thank you for the super chat, $2.99. But I'm going to get you guys into the documents. Let me throw that up here too. Boom. Thank you for the super chat. And again, for all you new people out there, hit that subscribe button. We got a lot to go through. So without further ado, let's hit up the Steve McRae document. Boom. All right. So this is what Steve's lawyer submitted today. I think they put it out because of all the craziness that's been going on online. So let's go through it. All right. So this is an affidavit of service for Steve McRae. Now I've read through this and it says, I'm Steve McRae, he's over 18, blah, 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 blah. So he's now talking about the defendants mostly set aside the judgment. So this is what he says. This is Steve again. So he's saying, through my dealings with Mr. Curtis, he represented to me that he lived in North Carolina and that his address was 1532, blah, 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 right? So that's the old address. And I understood that he lived at that address with his parents. The documents prepared by Mr. Curtis listed this address. So he says, okay, I got the documents. They listed that address. For example, around the time of the forming of non sequitur. So we're talking about in 2017, right? Around the time of the forming. Mr. Curtis prepared a fictitious business name statement for the filing of North Carolina at that address. A true and accurate copy of this document is prepared by Mr. Curtis and it is attached. But the problem here is that document's over a year old, right? It's in 2017. That's when they started forming. Am I wrong with that, Spackle? What do you think?
No, it's like 2017. And also, like, I'm kind of stuck on, like, how is it Kyle's responsibility to keep his would-be servers updated on his most current address? Like, how is this relevant, really? Like,
well, the first thing, but let's just start with, they're using a document from 2017 and saying Kyle said his address was this in 2017. I think that's irrelevant to 2019. 2 years ago, he said he lived at this place 2 years ago. That it's like, it's meaningless right now. You know what I mean?
Especially as a renter, most renters. I mean, a good portion of renters do change their residence like once a year, even because it's like a year contract. You change constantly. So like it's silly.
Let me get this for $5 super chat from Trolls, Haters, and Naysayers channel. That's right. That's what this is. $5 super chat, $4.99, but I'm rounded up to $5. Please give 5% of this super chat to Steve. No, because I don't want the tax liability. You know how that goes. But thank you for the super chat. Trolls, Haters, and Naysayers channel. Boom. I like it. I might even change the name. All right, here we go from Science First, my brother. From another mother. Science First. All right. These streams make the circus worthwhile. Thank you. $1. It's not $1.99. It's £1. I'm gonna call it £2. £2 for my man Science First. Thank you for the super chat. All right. So let's get back to the document. So what do you guys think about the first piece of evidence? We got a document prepared 2 years ago. He said, Kyle said his address was here 2 years ago. That's not convincing to me. What do you guys think?
Well, like I said, like renters change their address quite often. Like because I don't know, depending on where you are, like rent control isn't a thing in certain places. So like to me, like 2 years ago as a renter, anything could change, like for sure. Like it's just like, so I don't.
It's a so what? It's like, so what? Yeah,
Right.
2 years ago I lived there. So what? We're talking about, I said I moved in July last year, not 2 years ago. So I don't know. It is what it is.
Nate, I would call it lazy legwork.
Probably, yeah.
Because I could understand if somebody had lived at that address 6 months ago, you might not have been able to catch it or follow up on it. But 2 years, you should be able to find that in the system somewhere, because somewhere somebody had updated a driver's license, they'd paid taxes. There's a record somewhere that can be found as to where the person lives.
Well, so I'm saying this first piece of evidence.
Now, I want to throw something out here.
It's irrelevant.
That does not mean that people on the internet go look for that stuff. That it's for the lawyer to do, not you.
So, yes, I agree 100%. So that first thing is garbage. The second thing, the email correspondence concerning non sequitur show Mr. Curtis' signature block listed his address, right? A true and accurate. So they're saying on his signature block on the email, it said that. A little bit more convincing. Okay, his email signature had this old address. And so now this is another thing Steve is saying. At no time prior to the filing of the lawsuit and service of summons and complaint on August 3rd, did Mr. Curtis did Mr. Curtis or anyone else tell me that Mr. Curtis moved from that address. So Steve is saying that no one told him, but
because he's the
I've
first on
moved.
my list.
Yeah, like
I moved, Steve, by the way.
Is it Kyle's responsibility to say, oh yeah, by the way, I moved like 2 days ago? No, this is this is garbage here.
In case you want to serve me.
Yeah. Just in case you want to stir me to a lawsuit. Yeah, just to let you know I moved. $5 super chat from Angry Roach. And Steve knew Kyle had moved. Yeah, we haven't even gotten to that part. This is Steve's again, so everybody knows where we're at. This is Steve's affidavit. Steve is saying these are the reasons why the motion to set aside the default judgment should be set aside. So he's saying that from a document 2 years ago, Kyle listed his address as what it was. So 2 years ago. Then he's also saying, what was the other thing? He's saying, let me go back to the document. He's also saying that Kyle never told him that he moved. And he said his email, on the bottom of his email signature said that was his address. So let's go to number 7. After the lawsuit was served, Kyle participated in various internet venues and correspondence, which he acknowledged the lawsuit had been filed and that he had notice of it. All right. And then he gives some examples. October 6th, he had a chat on Discord and he acknowledged it. Look at it. It gives timestamps and the Discord link. But again, this has to be verified because right now it's kind of like, okay, you gotta, I need to know what time, when this was recorded.
By the way, that Discord where that audio link was attained, breaking the rules of that Discord. But that's another ethical concern.
Well, also in a YouTube interview, I think that's with the Unirock interview, he said Kyle acknowledged that he did not appear in court and had lied about having an attorney. But that, again, this has nothing to do with whether he moved or not. So they're saying, so now he's trying to make the thing that Kyle knew about the lawsuit. So,
but knowing in lawsuit, and again, I'm ignorant, so treat me, as an average Joe. Knowing there's a lawsuit going, like a creditor might be suing me, like versus actually getting served. Those are two different things. Am I?
Well, you're 100% correct. But let's do this. Let's go. You know what? I was going to do this later, but let me show you. Let's look at this right now. So this is North Carolina law. This is, I'm going to screenshot. This is the relevant case law on the topic of someone actually knowing about the lawsuit. So let me pull this up real quick so you guys can see it. All right. Hopefully that'll be big and bold for everybody to see. I think I need to blow it up so the audience can see it a little bit more. Yes, make it bigger. All right. So this is what North Carolina says. So see this case, Thomas and Howard versus blah, blah, blah. In this case, it cites this. While a defective service of process may give the defending party sufficient and actual notice of the proceedings. I think I'm gonna have to read that one again. While a defective service of process may give the defending party sufficient and actual notice of the proceedings. That means that person actually knew. Such actual notice does not give the court jurisdiction over the party. Absent valid service of process, the court does not acquire personal jurisdiction of the defendant, and the action must be dismissed. Citation. So the court, the court has ruled already on this issue that just because you know does not mean that is proper service of process. And that's what this is saying. So this is from the second highest court in North Carolina. Does that seem clear to you guys or no?
Yeah.
So based on that previous case, they've already kind of gone through this before, saying knowing is not the same as actually being properly served then.
Yeah, and it makes sense because people can be screaming, "Hey, I'm going to sue you, or I'm suing you." But until you give me the paperwork, you haven't sued anybody. You know what I'm saying? And that's what this is talking about. This is talking about having actual knowledge that you're being sued means nothing. You have to have the service has to be done properly. So I don't know what Steve's contention is, but we're about to go back to his document. $2 super chat from Drunken Important Wizard. Original process not served with restricted cert mail? ? Original process not served with restricted cert mail. I'm not sure the question. I would say it was served with by certified mail, but it was just served on the wrong address and on the wrong party. That's essentially what we have here. Let me go back to the document that we're looking at, Steve's actually affidavit, so we can see what else he's saying. So this contention that Kyle knew is irrelevant. It seems to be irrelevant based on what we've been seeing from North Carolina. So let's continue on. So Steve then goes on to go and says in the revised motion, he puts a link to the 45-minute video of me. So this is Steve's talking about the video. So Kyle puts a quick edited video, 54-second video. The full interview where a short snippet is taken, occurred on, he puts the date it occurred, that can be found at the link. So he puts the link in. The interview was over 2 hours long and covered a range of topics, including the lawsuit. The snippet offered by Mr. Curtis starts at 55 minutes. The interview and I discussed Mr. Curtis on the other halves, where allegedly that I had doxed Mr. Curtis by including his address in the summons, which was filed in the North Carolina Business Court. I had two basic rejoinders to the allegations. I don't know why he has rejoinders, but it's interesting wording. That I had doxed Mr. Curtis. First, the summons was a public document filed by the court. And second, that the address was supposedly incorrect anyway. Okay, that's what he said. For this reason, I stated in an interview that the address was wrong. Is that what other people told me? The reason I stated in the interview that the address was wrong is that's what other people told me. So Steve is saying essentially with this that he didn't say that was Kyle's old address. He's saying other people said that and he was just agreeing with it, right? Am I reading this wrong? The reason I stated in the interview that the address was wrong is that other people told me after the filing became public that Mr. Curtis had moved. So he's saying he didn't know before they sent the doc. He knew only after they sent the document that Kyle Curtis had moved.
First of all, who wrote this? Because it sounds like poor English.
I think Steve might have wrote this.
Yeah.
I mean, like, I'm from California and everything, but I would totally rewrite this and resubmit because it's really bad, guys.
And I'm sorry, but a lawyer isn't going to use the word doxed.
Yeah, I think Steve wrote this out.
And as the judge, I think I might have to ask Mr. McCrae here to please define the word doxed.
but let's understand what he's saying. He's saying that number one, he didn't know that Kyle had moved before this, and that he was just agreeing with other people. So is Steve lying here? This seems like a lie, right? This seems like a lie. You know what? Just to be clear, let's do this. Let's see what Steve said a couple of days ago, right? I have the clip already queued up. Let's see if Steve knew before he served Kyle that he had moved, because that's what he said in that clip. He's saying that no, he actually didn't know. He found it afterwards, right? So let's see if let's see if Steve actually knew. I'm going to play this clip recently. This is a recent clip. Non sequitur. All right, here we go. And let's see what Steve says. Can you guys see that? I got to do this again, so you guys can hear this. All right. Screen share. All right, share audio. Almost forgot to hit the share audio. And let's listen to Steve. Now, what's your opinions on this, guys? Let's see if Steve. All right, here we go. Turn this up too because it gets low sometimes. And turn this up. All right, here we go.
Show me evidence that he was served properly. The address that he was served from, which was a family member's address, which we knew was an old address. I knew that we knew that was an old address, but that's fine. He had no forwarding information on it, and an adult signed for it.
So what do you think? What do you guys think?
His stating that he knew it was an old address and it's stating that it was fine. No, I'm sorry, you can't do that.
I'm just gonna say, don't accept good enough as good enough.
Yeah.
I mean, it's
Yeah,
kind of good
close-
enough.
Yeah, we're not playing horseshoes here, people.
Oh my god! But so am I wrong? Where he knew he sent it to the wrong address, and he's trying to tell the court that he didn't know it was the wrong address? Because here he's saying it, he knew it was the wrong address, right?
It sounds like he knew that it was the wrong address, and he just was throwing darts. And he's like, "Okay, I guess this is what we got, so let's go with it." But can I ask something? And this might be
Go
a
ahead.
deterrent. If you were Steve's lawyer, put your thinking hat on here. How do you ensure proper service? How is this? Like, do people take a picture, thumbprint here? Like, how do you?
Well, no, you can personally serve it, just hand it to the person. There's a whole bunch of ways you can properly serve, or send, or you know what, mail it to their actual address. There it is, mail it certified, mail to their actual address, and that would be proper service. That's the contention here. Wasn't his proper address, and Steve is saying, well, actually, he's saying it wasn't his proper address. There seems to be no contention whether it was Kyle's actual address or not. It seems like Steve is saying it wasn't. Hold on, let me see this other clip, because there's another clip here. I want to see if this is Steve.
I said that it wasn't his it was his last known address, which I said wasn't. He had said he had moved. This is why I said that it wasn't his.
I gotta wait for the, what's this thing, the ad to play through. No ads. All right, skip ad. All right, so let's listen to Steve again. I'll mute this.
That he had moved. This is why I said that it wasn't his. I said it was an old address, right? I remember I said that very specifically, and some disreputable people have latched on that and said to him, "Hey, look, he's."
So he said that this was an old address. I think there's another clip right there too of him saying this is an old address. Let's listen to this one again.
Said that was an old address. I was very honest about that.
All right, here we go.
We knew that it was his last known address. We knew that he had moved. And that's perfectly fine. I said that was an old address. I was very honest about that. But what I think happened is that some disreputable people had heard me say it was his old address and told Kyle, "Oh, look, Kyle, it's your old address. Therefore, the service is no good."
So I'm sorry, guys. This seems like he's lying. It really does to me seem like he's lying.
Nate, I'd just like to make I don't want to use the word statement.
Go ahead.
But this is what happens when you try to maintain a narrative. The more questions you get asked, the longer it goes on, your narrative starts to skew because you're always trying to correct what you said previously.
But he's now signed a document to the court under penalty of perjury saying, "I did not know that he had moved before we served," and he's on stream saying, "Yes, I did know. Yes, I did know." What the hell is he doing?
Since this whole drama started, everybody's been wondering, why does this guy keep going on the internet telling everybody about the court case as it's unfolding before he does shit?
I think if anything, it's taught us that we need to go quiet. Like, if we're pulled into court, we don't want to blast this on Twitter and the internets. We probably want to be quiet until the fat lady is sung, because otherwise, if you're saying one thing and then saying another, I think it can prove like this does sound like a lie. This sounds like he caught himself in a lie.
Well, hold on. Let me get my Learning with Suge. Thank you so much for the $15 super chat. I love you, bro. The whole thing has been quite enjoyable. Funniest courtroom drama since My Cousin Vinny. I agree with you 100%. Thank you, Learning with Suge.
But My Cousin Vinny was serious courtroom drama.
Thanks for the super chat. I really appreciate it. So, I'm sorry. Go ahead, Spackle, because I know you. I didn't mean to cut you off.
Is it possible that this weird response that we saw recently, which seemed poor and weak, is it possible that he's trying to cover himself because he signed an affidavit? I believe this to be true, and this response is sheer just kind of cover himself, saying, "No, I this link that he provided is out of context." Like, do you think he's all focused on that?
I don't know. This is a straight up lie. I'm just going to be straight up with you. To me, this is a straight up lie. He knew that Kyle had moved. He says he knew that Kyle had moved. He said it previously. He said it on this stream that we just saw. He is just lying. And it is and I don't know why you would lie to the court, but that's what seems to be happening here. This just seems to be a straight up lie. I don't know how what else you could say about it. One on that super chat from Nikid Manhole. Steve should have taken him to Steve should have taken him to people's court. That's true. $2 super chat. Thank you so much. What you about to say? I'm sorry to cut you off.
I was just saying that Steve has honor and integrity. And I've spoken with Nick Suter on a blog argument, and he has told me that Steve doesn't lie. In fact, he has never known Steve to tell a lie. And lying just simply means when you know that you're telling a lie. Then, if you're deliberately being dishonest, then that's what a lie is.
See, look at this. For trolls, haters, naysayers channel, $5 super chat. Steve doesn't lie. He has honor and integrity. Well, hey,
honor and integrity.
Whatever it is, this doesn't seem to be true. What he's saying now seems to not be true under penalty of perjury. So he's saying he didn't know. Failure to comply with the default judgment. So he talks about the failure. He didn't get all the passwords and primary ownership. So now he's talking about the default judgment. And then Steve signs it, right, under penalty of perjury. Right. So now he's signing this under penalty of perjury, which I think may be a problem, Steve. But to show you how bad I think this starts to get, look at this. Subscribers sworn to me on the 12th day of January. So he made this a month ago. So this was notarized a month ago, right?
Wait. Why would he do that a month ago?
He didn't do this a month ago. It can't be a month ago because some of these facts didn't even happen till then.
Oh goodness.
They messed up. He totally messed up. This was he couldn't have attested to this January 12th because Kyle didn't even file he didn't file his motion.
Who typed
a couple of days ago this.
Who typed this?
I don't know, but this is a horrible error.
My God.
How could he attest to something that didn't even happen a month ago?
What paralegal messed this up, or is this Steve himself? As we've seen, the grammar looks like Steve up above.
I don't know. Steve doesn't lie. Oh yeah, I forgot. I got you already, trolls. Yeah, but this is crazy. This is insane. So the notary didn't know that like it's February. He put January.
The notary might be legally blind. Okay, like you don't know.
Angry Roads, $10. This is funny as hell. This is tragic, my friend. This is tragic. This is tragic crap.
Nate, I could understand if this was on the first, because this paper here where it says day of January is typed out, and then the 12 is handwritten in. So if this form was used on the first of the month, you had the form from last month and you haven't switched the form over. I understand that could happen, but this is 12 days after the fact.
I understand accidents happen, but he's now attesting the stuff. In other words, Steve is attesting stuff. He's saying that he predicted this in the future. He predicted Kyle's motion in the future. This is insane. $2 super chat from Agrippa. Steve is using SCP definitions for truth. Thank you, you troll. You troll. Thank you for your £2 super chat. Thank you, good sir. Thank you. Yeah, this is crazy. This is insane. This is insane. All right, so Steve now last month certified that all this was true before Kyle did it. So he's got foresight. He's got foresight. Damn, and this is the first document we looked at, right? This is the first document. So a month ago. That's when he certified this. Now, how much do you think that the date on the next document is going to be different? Because this is the certification of notary, right? Certified, and let's see the date. February. I can't even say, but I'm assuming it's 12th. February 12th.
The first problem is it's Riverside.
Oh my God.
I'm just saying.
So in one document, he has his February 12th, but on the document signing for his affidavit.
Nate, scroll back to that. Scroll back.
Go ahead.
Here.
Mm-hmm.
Scroll back to where you showed the first date there on that 12th there.
This one.
Take a good hard look at that 12. No, down.
Right here. Oh, the 12th here.
Yeah, where it says the February 12th. Take a good hard look at that 12. What does it look like?
It looks like a 12, kind of like a 1. Like it was an accident. So
And
they
then the
tried
next
to
one
redo
down,
it.
the next one down.
Okay.
Now that one there.
11th, 12th.
Yeah, this one. 11th, 12th. Yeah.
Yeah. Someone's
my
filling their
God.
paperwork out. They're not looking at a goddamn calendar.
No. This is so Steve is, I don't know. This is just sloppy stuff. Steve, you're trying to win a lawsuit here. We can't have mistakes like this. You can't swear to documents before events happen. You're swearing to documents a month before the guy filed. How do you know? It seems like this is now hearsay because this is bullshit. But don't forget, let's be fair. Steve has a super lawyer. And the super lawyer catches these type of things. So I got another super chat for $5. Now, Steve will have perfectly logical explanation for the date discrepancy. He has mastered time travel. Possibly true. He needs to get those lotto numbers. And Steve, hit me up with them lotto numbers because this ain't working for you. Here's another $2 super chat from Mr. O. That doesn't appear to be a legitimate notary. Uh-oh. Now we're talking the notary's got to be questioned. Thank you, Mr. O. You guys are hitting Steve and the super lawyer real hard. But hey, we all make mistakes. So that's Steve's story. So let's just make sure we wrap it up for Steve's story for the fans out here, people who are going to be watching this. So number one, Steve said he didn't know Kyle moved, right? Somebody else told him, and he didn't know Kyle moved before he did the documents. And the proof that he has to overcome Kyle's proof is that Kyle left his old address on his email, a document 2 years ago that they filled out. He used an old address because he was living there. And what was the other thing? There was like one other nonsense thing that he pointed to. That Kyle didn't personally tell him that he had moved. So those are the three pieces of evidence. Oh, I don't know if I got that.
Because that's the first thing I do is like, let me call this
the person who's going to sue me.
This asshole. Let me call and tell him where I live.
Oh my God, this is insane. Christina, thank you so much for the super chat. Isn't the notary backdating legal? Uh-oh. Listen, I can't answer those questions. I don't know about whether it's legal or not. I just know that, this was dated in the month of January. So this is backdated pretty far. They were complaining about Kyle backdating invoices. Now you're talking about that he backdated a whole affidavit for a lawsuit. So
I feel like that it was just pure incompetence. Like this is just incompetence and proofreading, but
Yeah, but this is incompetence and proofreading. He spelled someone's name wrong or a grammatical error. You don't screw up the date.
If you had a good laugh, hit the like button. That's true. Thank you, Angry Roach. Hit the like button if this is funny to you, because this is pretty funny. Thanks for the $2, Angry Roach. Angry Roach, I love you, bro. I got to make you a mod. You're already a mod. I got to mod you up. You and a couple other people too. Let me see. You missed Raphael Block's super chat. Sorry. Thank you, Trisha, for $2.99. Let me see. Raphael Blocks. I missed your super chat.
I'm looking with you real quick.
Can I get you? Raphael Blocks. No.
I see it. It's you want me to read it?
Yeah, read it out for me.
Raphael Block says for $2. Thank you, Raphael. Steve is using Rule 5 for his claim of last Addy. And is there anything else besides that? I think that's the only one.
Well, usually it's because I know here we're talking about Rule 4. I think Rule 5 is for cross complaints and stuff. So I don't know. I'm not a North Carolina lawyer, so I don't know. Johan Rodick says hello to Tony Desires. Tony, you're getting too much love on here, but thank you for the $2 super chat, Roddock. I really appreciate it. All right, so we've just gone through Steve's affidavit. And to me, I'm just, we'll give our feelings on it. My feelings are it's full of lies, mistruths, and nonsense, to be honest with you. And the date of the notary is wrong. So that document is crazy. And I'm surprised that, you would suspect someone who actually is paying their lawyers to do this would just be a little tighter than this. What do you guys think?
Well, it almost looks like Steve's his own lawyer in this one. Like I would have guessed that, like especially the way that this one was written out and stuff. I'm kind of shocked that a professional would let this fly and be like, this is fine, this is okay. It just blows my mind. Real quick though, I really wanted to ask real fast, what if the address that he did send that to, what if that was associated with his business? Would that still count as service or not service?
Well, that may actually count. But let me do two things. I got super chats are hitting me fast right now. So let me hit these super chats up, and I'll answer. But if it was associated with the business, yes, it would count because it's the business address. So yes, it would count. But then you're serving the business, not the person. So it's a couple of things we have to unwrap with that. First, $5 from Kelly. Kelly, I don't want to chop up your last name, so I know it's Nelwaja. I hope I'm pronouncing that correctly. Could the notary be liable for not catching if the incorrect date caused this to be tossed out or worse? I'm not sure. I'm not sure if the notary. I'm not even sure if the notary wrote that up. It's it's an interesting question, but I just really don't know. Do you guys know, or do you guys have any opinion on that?
Can they amend it? Can they just like?
I assume you can amend it because it's people make mistakes all the time. Like Kyle, I think Kyle made a couple of mistakes on his. It is what it is. Nobody's perfect. So, but I just I hate the fact. I bet you for a fact Steve is out there pointing out all the discrepancies in Kyle's, and his is just like a piece of crap right here. So it is what it is. Hey, Kofi Aaron. You wonderful troll, you. This is from Yuhan Radak of $2 super chat. Thank you. And hey, I'm sorry, Kofi. Keon is my boy. Keon, number one, baby. I love you, Keon. Thank you for the super chat, though. Learning with Suge, $10. Suge, we love you, baby. There you go. Steve's ability to pick out a good lawyer is on par with his ability to pick out an honorable man. Oh, that's the Earl David Warden hit. Boom.
You might want to add something else. His ability to also pick out a good notary.
Thank you for the $10 super chat. Trolls, haters, and naysayers channel. I hate having to say that long ad. We got to shorten that name, baby. But here, Steve's birthday is in 2 days. How if he messed up? How if he messed up? Is that maybe?
No, I think that's a the and an F word.
Oh, okay. Yeah, that's true. It would be. Thank you, trolls, haters, and naysayers. So let me read that. How blank. Oh, how the blank he messed up. Yeah. It's a screw up. It is a screw up. Thank you for the super chat. Just scrolling down to see. All right, so we finished with the first document. A lot of lies, a lot of things, a lot of nonsense in it. Doesn't really seem to be anything relevant. He's saying, I just didn't know. So, we saw the North Carolina law and the cases that say it doesn't matter if you knew or not. So how will the judge rule? I just don't know. But now let's go to what the lawyer put through. The lawyer actually gave us a motion to dismiss. So let's look at what the lawyer put out to see what he is saying about Kyle's motion. I don't know what is happening. Okay, so I got this. All right. Here is the response to the motion to dismiss. Let me blow this up so we can all see it. Let me go to the top. So this is the response by Steve's lawyer to Kyle's motion to dismiss. So we're going to be looking through this. Just looking. Let me know if there's any super chats out there, guys. And let's just go through. Now, this is not going to be a one-on-one read. We're going to go we're gonna go nice and slow. I'm not gonna go through the whole document, but just the highlights of this because we'll be here all night. So this is the counsel for Steve McRae. They go into the matter before the court. So this is just like an overview of what happened in the past. They started on January 23rd, the default judgment when that happened. So they're going through all the past, right? Statement of relevant facts. So the relevant facts is they filed the lawsuit on this day. They sent the summons, the complaint return receipt to Kyle's old address. The postal service, they tracked it. He got it on August 30th. So the date August 30th is the total we're talking about. So here they put the address was the one used by Kyle Kurtz in his dealings with Mr. McRae, and they point to McRae's affidavit. So in his dealings, remember that McCrae said that was because he signed the form 2 years ago. So that's what they're pointing to. So 2 years ago, in his dealings with Mr. McCrae, that was the address. And for example, you see the Mr. Curtis prepared the fictitious business name statement filing in California, but it doesn't say here that was 2017. So what do you guys think about this argument by the lawyer? Uh-oh, I think I lost you guys. But I do have some super chats to read out. Oh, you guys are fighting in the chat. You guys are chat fighting.
I'm not bad fighting.
I see you. Hold on, let me do this. Let me go to Tadded's $5 super chat real quick. This super chat is for 1994 notary, notarized by Steve. Hold on, this super chat is from 1994, notarized by Steve Notary. Tadded, thanks for the super chat for $5. Oh man, it's real. That's hilarious. Yeah, from 1994. Okay, here we go. Steve Notary will notarize anything, it looks like. This is from Patty Brendan. Yeah, Brendan. I was told my parents ad was my perm ad. Am I misreading this?
I was told my parents' address was my permanent address. I mean, that would be fine if you're Cheshire and you're living off of your parents. But if you're not living off of your parents, hopefully not, like that might not be your permanent address.
Yeah, but the thing is, the permanent your primary address, your permanent address is where you live now, where you get your mail, where all your stuff is coming to. If it's your parents' house, then that's it. But where you get all your stuff. If your parents live in, let's say, New York, and you live in, Wisconsin, your parents' address is your permanent address, which is where you move to. It's where you live at, where you reside. It's your usual place of abode. That's what they call it. But thank you for the super chat. It's $2 super chat. I really appreciate it. So let's go back to the document now. So Steve's lawyers are relying on this 2-year-old document again. So he's saying the 2-year-old document is the first point of proof. The email. So he's now talking about the email. See, the email correspondence with the non sequitur show. So now he's pointing back to the email. So the email property records show that is now owned by who are related. So now he's saying that the house that they sent it to is owned by his parents. And in that way, that's proof that they related to Kyle. What does that have to do with anything? Okay, so his parents live there.
Okay.
You first.
Go ahead, guys.
First.
Okay. Let's say you live in a building which is owned by a property owner because you rent. Does it matter who the property owner is?
No, not really.
No. They got to send the paper to you, not the property. Otherwise, if you want to do this shit, no, you just send a letter to the property or say a management company for an apartment building. There you go. You served everybody.
So my question is, if I'm Susie Curtis and I get this thing and it's like your son being sued, Hearts, Steve McCrae, am I obligated to hand that? Be like, son, looks like they're suing you again. What happens? What happens if Susie just goes,
toss it in the mail?
Yeah. What happens then? What happens?
It's the same thing. That's what's called it's not proper service because if he has to live, if he lived there and she tossed it, then you got a problem because it's proper service. But if he doesn't live there, then you got nothing. And that's what they're trying to overcome now. There's no contention here that I've read so far that says that Kyle lived at this address. It seems like everybody's admitting Kyle did not live there.
Kyle, you need to come and get some blueberry pancakes and also pick up this mail. They're done sued you.
Let's see what else. The summons and complaint were not on the only items the address. Okay, so on July 17th, Counselor Mr. McCrae mailed a letter to the address. Okay, so who cares? See, yeah, he made all right. So you mailed a letter to that address. Okay, who cares, right? On July 17th, he said he moved out on the 15th. Anyway, on August 29th, a notice to preserve data was sent to the same address and mailing address. A copy of the letter was attached to Exhibit C. So again, they're hanging their hats on the fact they're sending it to old addresses. That because they're sending stuff to old addresses, they're saying that should mean something. I don't understand it. Do you guys see what I'm saying? Mm-hmm. The lawyer's saying I'm sending all my mail to the old address. So what? This matter of fact, am I reading this wrong, or what do you guys think? The lawyer's saying we're sending all our letters to this address. That should mean something. Does that mean anything to you guys? Does that mean that Kyle lives there now? I don't understand the point of this argument. It just seems
the letters
ridiculous.
could be just piling up and collecting dust, right? Like it doesn't matter that you send a ton of letters to an address that the person isn't living at, right? Like and you're just assuming that they're going to go to this old address and retrieve it. What if he's estranged with his relative? You're assuming because it's his, relative that he's going to come over. What if he's estranged? Like how can you assume that?
I don't know. This is really bad. This is really bad. Okay, so hold on. Let me just read this next one. Okay. The affidavit of service of process and motion for default were both mailed. Yeah, so I don't know. They're just admitting we mailed everything to the wrong address. Yeah, that's the problem. That's why he's asking for this. This is ridiculous. Go ahead. I'm sorry.
Okay. When you move, you can get your mail forwarded
for 6 months.
New address. For so many months. But this original letter here, the letter that served Kyle, that was a certified letter. I don't believe certified letters can be forwarded.
Well, I don't know.
So that's a good question. All this stuff about knowing the previous address, we said it all there. I'm sorry. I don't feel you could forward court documents. They got to kind of go to where they got to go.
Yeah.
Otherwise, they're undeliverable.
They have to go to the address. They have to go to the person's address. That's it. It's plain and simple. You can't send it like Angry Roach for $5. Thank you for the super chat. I think he makes a great point. If I want to sue Drags Fat Blank, who lives in Texas now, can I send the papers to his old address in Louisiana?
Yeah, because Drag's mom's gonna hand him that and be like, "Look, they done sued you."
Again, that's why this is stupid. I'm not even going to. I don't want to say the wrong things about this guy. This is tragic. This is unfortunately tragic, and I know but maybe I got to say maybe it's something I'm just not seeing. This just does not seem. We talking about Kyle stuff was horrible. This stuff is pretty bad too. All right, so let's just continue to keep it moving forward. Okay, so they're more or less saying we sent everything to this old address, right? We sent everything to the old address. Okay, you sent it all to the old address. That's the problem. You didn't send it to the right address. None of the letters listed. So now, none of the letters listed were said they were undeliverable. Yeah, you were sending it to his wrong address. So just because they don't even argue the contention that was Kyle's old address. They seem to admit it here, right? And even Steve saying that it was Kyle's old address. So everybody admits this is his old address. So what are the legal arguments that they're going to put forward to say this should not be dismissed? So defendant's evidence concerning his address. Okay, so now they're going to attack the evidence that Kyle put forward. Right. So now this will be
good. This is the juicy part, right?
All right. So let's see. All right. I'm hoping so. This is, it's not been so juicy. It's been pretty wild. Have I missed any super chats? Just keep an eye on it for me. If I have, let me see. Last one was Drags one. All right, cool. So let me thank you. That's a big yawn. Thanks again for that, Angry Roach. I really appreciate it, man. So let's go back to this. Okay. So the defendant filed a motion to set aside the judgment. Yeah, we know all this, blah, 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 blah. So this he says both include affidavits from the defendant stating that he moved on July 15th, address to Charlotte. Yes, this is the only sworn affidavit. Yes, so the defendant has a sworn affidavit saying I moved. So that's the only sworn affidavit. The revised motion will include several unsworn items and inadmissible hearsay. So so remember he had an affidavit from I think his mom and an affidavit from the landlord. So he's saying that since they are not not notarized, then they're hearsay. There are two documents titled Affidavit of Residence, purportedly signed by Susan Kurtz and Benjamin Ports, saying the defendant lived but neither of the purported affidavits are notarized. Why would you put this in here? Because now you what you've done is effectively tell Kyle, guess what you should do?
You should get it notarized.
No. Do you think that would
should.
be a good thing to do?
I'm not a lawyer, but I would guess that if he goes and gets this notarized, he can update. Like, I'm just saying.
Yes, yes. Oh, guess what? You know what? That's a very good idea. Let me go get these notarized and then turn them in. Like, what? Who's he working for now? You know what I'm saying? Is he working for Kyle now? You know? I don't know.
Maybe this lawyer just wants out. I mean, we all reach a point where we want out of Steve McRae's crazy. I was a mod for him for a certain extent of time. I understand. Like, eventually you just can't stand by him. Maybe the lawyer just wants out. Like, that's my explanation. It makes sense to me.
Well, Kyle should be saying thank you, because now I know what I have to do. I have to get these notarized. Let's see what else he says. Okay, the defendant has also attached a copy of the rental agreement, right? A credit card statement and a 1099 form showing his Charlotte address. Okay, so now we got these three things. So how's he going to tear those down? Finally, the defendant attached the call of the transcript. Okay, so now we got the YouTube video he mentions. Okay, so now he's going to talk to us while all this other stuff is trash. None of the attachments to the defendant's motion, even the unsworn statements, provide any evidence the defendant failed to receive notice of the lawsuit. It's not. It's supposed to show that he didn't live where you sent the. What is he talking about? All right. So the rental agreement, they don't. He's not attacking. He's not attacking the credit card statement, and he's not attacking the tax documents that all show that Kyle lives somewhere else. And the YouTube video, he's not attacking that either. So they're saying, okay, you got that, but they don't show that he didn't have notice of the lawsuit. It's not about him having notice. It's whether he was served at his address.
He does slightly attack at the YouTube thing. He says obviously doctored snippet. So I mean, all that means is show the whole thing, and then also show like the 4 other videos of him saying this stupid stuff.
Oh, he says that one of the altered from the affidavit that apparently is altered in the way to delivery of. Okay, he says that one of the things were altered because I think the date changed. Well, I don't know. Well, it seems like even if we're talking about bad notary stamps, it seems like you got a problem on both sides with this, right? Because Steve's notary stamp says he attested to this stuff a month ago. So yeah. Oh my God, this is crazy. All right, so now we get some arguments here. So let's just be clear. They're not even attacking the evidence. They're not even saying Kyle did. So this really is going to come down. Did Kyle live there? They're saying no. Kyle's saying no. And he's more or less telling us what to do so Kyle can show for beyond a shadow of a doubt. So motion to set aside. So he's saying that Rule 12B, he's still giving us the standard abuse of discretion. This is just legal junk that you guys don't really need to know or even care. But service was improper and judgment is. So he's saying, and this is just a statement, service was proper and judgment void, but he doesn't tell us why, right? Doesn't really tell us why. Service is presumed. That this is what I was talking about last stream, where if you do service, they generally presume it, and it's on the defendant to overcome that presumption through evidence. And I think Kyle has presented some evidence here. It seems like he's saying that Kyle didn't present any evidence. He does actually make the point that the presumption does not require that the signature of the actual addressee, which is true. But again, he's not really attacking the evidence, because again, the presumption is Kyle was served correctly, and to overcome that presumption, you have to show that through some evidence. And Kyle has presented evidence, and they haven't even attacked that evidence. I'm just trying to see if I missed any super chats. If I did miss any super chats, I am so sorry, but I will definitely get back to it. Nothing is missing. All right, so at this point in time, I'm just going through it. Defendant had actual notice of the lawsuit and has failed to rebut the presumption of proper service. No, this is what is this? The fact that he has actual notice has nothing to do with proper service. Go ahead, Holy. It's not like you want to say
that's what I was gonna say. So again, if you know, let's use the creditor analogy. If you know a creditor suing you, let's say you bought a mattress and you screwed up, and the creditor's like, "Where's my money?" And then you're like, get the phone calls, and then it's escalating, and you're like, I'm about ready to get sued. Like, you might know that you might be getting sued, but you might not know that you've been getting sued. Like, you still have to be served. Like you can't just like suspect that you're being sued, or somebody go, I happen to work for X creditor, and I happen to know, like, I saw you on the list and you might be getting sued. Like, that's like hearsay, right? Like, you can't, like, and I gotta point out something. Like, there's somebody on the internet that always screams that he's suing people, and Dragnut's getting sued, and I'm getting sued, and apparently Sock Account way out in Canada's getting sued. Everybody's getting sued.
He's coming to my house.
Oh yeah, is he suing you yet? Because he's going to sue me in California, and he's going to sue Drag in Texas, right? Like, this is a whole nother person, right? Like, we hear this all the time on the internet. These lull suits, as we call it, like,
Yes.
like, we always know, like, there's somebody shaking their fists wanting some sort of internet justice, right? So, like, what if Kyle's just like, I'm waiting for you to take it seriously when somebody shows up and says, you, sir, have been served face to face,
Well, listen, this is pretty insane. This is just pretty insane. Like, even with this last part, I'm just reading through this last part, right? He's going into the presumption. Now, everything that I've been reading, the presumption is about, proper service. So if Kyle can prove that he didn't live there, service is improper and the case has to start again. Essentially what he's saying. So he's saying, present evidence that the service of process failed to accomplish the goal of providing the defendant with notice of the suit, rather than simply questioning the identity, role, or authority of the person who signed delivery of the summons. What? No, he's not questioning the authority of the person who did any of that. He's saying, you served the wrong person at the wrong address. That's what this comes down to. You served Steve's lawyers, or Steve served the wrong person at the wrong address. He didn't live there. That's essentially what he's saying. So all this, now he's going into gamesmanship, like, procedural gamesmanship. It absolutely makes no sense, because the argument that he's making, that Kyle is making, is simply, you served the wrong address and you served the wrong person. Does that make sense?
Yeah, it does. But with the gamesmanship thing and it's not a child's game thing that he throws in there and search that in there, like, does the court put any weight in this weird sort of moralizing, so to speak?
It's advocacy. He's advocating for his client. I understand that. Hey, I would throw some stuff out there. Gamesmanship, this. He's trying to make it more compelling, but it's not compelling because the argument is simple. The simple argument is, you serve somebody else's address. You literally sent the damn thing to someone else's address and they signed for it. It happened to be my mom. I happen to know the person. But the fact of the matter, it wasn't me. I didn't live there. And here's the proof. Bank statements, rental agreements, and what else? Bank statements, rental agreement, and tax documents. See, I didn't live there. I don't know. And this is what Reds has been putting out there. Like, oh, this is such a great thing. This is, again, I just don't want to say. So the small piece, he then talks about the video. The video is bad. But again, we have other video. Like, this makes this even worse, is that they attacked this one video that Kyle's put out, forgetting there's like 5 videos where Steve says the same thing over and over again, how he knew Kyle didn't live there and he sent the papers there anyway. 5 videos. So if they want to go after this one little small snippet of a video, that makes no sense, because now when the judge sees 5 other videos where he's saying it, it's going to be like, okay, oh yeah, he actually did say it. What? Am I being too much with this?
I just think it's lesson learned to shut up. I mean, you have had other videos where, like Kyle and Steve have said things where it's like, just shut up. Like, if you're going through some sort of litigation online, the worst thing you could do is jump on YouTube and open your mouth. Like, I mean, lesson learned.
And so they're hanging. So this is what they're hanging their hat on, guys. It is obvious from this discussion that defendant knew about the complaint, since he was aggravated about being doxxed. However, defendant did not, again, doesn't really have any evidence for that, but however, defendant did not respond by providing his correct address or acting to quash service of process. The reason why is because you didn't serve him. You didn't serve him properly. Of course, he's not going to go and say, "Oh, excuse me, mister, you're trying to sue me for $100,000. Let me help you find me so you can sue me. This is where I'm at. This is how you need to sue me." That's your responsibility as the plaintiff, right? Does that make sense?
So what you have to understand is there's a philosophical definition of service. And until you understand this definition, I'm afraid I'm going to have to cite some experts. Like Ozzy agrees with me, and Alex Malpass agrees with me on my definition of service. I'm just saying.
It's funny because when Red was saying this stuff, I was like, "Oh, this is going to be good. They're going to smack Kyle down." Because I kept thinking, I was like, "What attorney would make these mistakes?" This attorney seems to make these mistakes, and hey, maybe they'll win. I don't even want to put the guy's name on it because it's just like, I feel bad for the guy because I've kind of torn it down, but this just seems and just so people don't think I'm just full of crap when I'm saying this, make sure they served it. And the funny part about it, look, they're serving it to the new address too, the address that they didn't know about. But just to show you guys again, it's not like this is. I just don't want you guys to think that it's just me saying that this is the rule. This is what we found from North Carolina. I'll show you the case law again, just so we can all be clear and on the same page. So we can all be clear and on the same page. Where is it at? Here it is. Should be up. Again, here are the cases. Generally, where the statute prescribes the method of service by which to notify a party. So again, this is a legal matter. This is exactly the way the law says the person is going to be notified. So then they give a citation. And then they put, while a defective service of process, that's what we have here. Defective service of process. It was sent to the wrong address. It was sent to his mom. It was sent to not only the wrong address, but signed by the wrong person. So you got two big issues here, right? While defective service of process may give the defending party, sufficient and actual notice of the proceeding, such actual notice does not give the court jurisdiction of the party. It is clear, and that's why at the end of this it says that the action must be dismissed. Now, it's kind of shocking, to be honest with you, that they're making this argument, understanding this. Now, maybe in North Carolina, I'm misreading something, but what do you guys think? Do you guys think this is a crazy argument? Do you guys think this is crazy? Do you guys think I'm just not getting it? Uh-oh.
I'm waiting for the Canadian to chime in, but
he just wants to look good on camera right here.
What would you like me to chime in on, Spackle?
No, we're asking. Well, you know what? Let me do this. Let's do something fun. I'm going to show people something else that is, I think, relevant to here. So you guys, because again, I'm in New York. I am not a North Carolina attorney. I don't know any of this. I don't know whether this is great service or not. I'm just reading the tea leaves off the case law and stuff. I could be totally wrong. But let's see what some North Carolina attorneys say, right? Attorneys who actually practice in North Carolina. Let's see what they say about this issue, because that would be the best place to go, right? Would you guys agree?
Yeah.
Oh yeah, because they practice law in North Carolina, presumably.
So here we go. Yeah. So let's go to some North Carolina attorneys and see what they say. So this is Woodruff. See their phone numbers up here. You guys can see them. These are North Carolina attorneys. They're divorce attorneys. So these are people who you need. If love is not going your way, you call these people, right? Call this number. This is the North Carolina Law Blog. This is from them, Woodruff Family Law Group, right? So they talk about it. So they give some scenarios about service, because this is about service, right? See, 4 and 5, civil procedure, spotting the differences. So let's look at scenario number 3. Let me blow this up so we can see it. So scenario number 3. Oops. Push this down a little bit. There we go. It says, I recently got a summons and complaint, but it was not given to me by a sheriff or by mail. It was delivered to my mom's address for some reason. I do not live with my mom, but she gave me the documents when I visited her this week. Is this proper service? Their answer, no. since this is regarding service of process, Rule 4 applies. Unless your mom is a registered agent with the Secretary of State, which she is not. And this service is not proper. Now, this is North Carolina attorneys saying, here's the same situation. And service of process is not proper.
So mama cannot invite you back for blueberry pancakes on Sunday and give you your mail that happens to have P.S. You're being sued by Steve McCrae hearts.
Yes.
Okay.
And this says that, and even in the scenario, it says, hey, we've given, we got, this person got the paper a week later from mom, right? We got it a week later. Boom.
Now,
what
Nate,
more do you need?
I do have a question here I'd like to ask.
Go ahead. Question, please.
When did Kyle make this website, and where is the metadata? Because this is a screenshot, and I don't believe it.
This is not a screen. This is the website. What do you mean a screenshot? This is the website. This is the damn website.
Where's the metadata? We need the metadata.
Clearly, this is a troll website because wood.
Yeah.
You know what that stands for, and then rough. That obviously means Cheshire. So rough.
Yeah. And look at this phone number.
Even their recent verdicts over
here.
here.
Of random numbers typed out,
Yeah, and they got all their recent verdicts and all this other stuff. Yeah, this is obviously, these aren't lawyers. This is just this is
scroll up to their media section there, down a little bit.
Down a little bit.
Yeah, where you get into their social media stuff.
Oh, okay.
Really. What kind of lawyer has a YouTube link on their page? Really?
So I don't know if I don't know, guys. Again, I gotta say, first, thank you all for the super chats. They were really wonderful. You guys were always so generous. And again, with these type of cases, a lot of times these videos don't get monetized because for some reason when you say words like atheist and lawsuit and all this other stuff, they demonetize all my stuff. But I hope you guys at least saw what I'm seeing. And again, if you guys think that I'm wrong with this, please, first I'm going to block you. No, there will be no blocking. If you think I'm wrong, please, let me know in the comment section.
I think you're wrong because I know that for a fact Steve has got honor and integrity, and I trust him.
And learning with suits, I do get monetized with some things, but they demonetized. They demonetized a lot of these videos that I do about this case, Matt Delahunty and Silverman case. They demonetized all those videos, and I forgot what other videos. So a lot of times anything dealing with a lawsuit, they demonetize. I just don't know why. So super chats is the only way these videos make any type of income. But thanks. You guys have been more than generous, and I really, really appreciate it. So does anybody have any questions in the chat? Because now again, we got we literally looked at North Carolina attorneys who said, hey, if send it to the wrong address, we've looked at Steve's issues and how he's notarizing things months before Kyle even filed stuff. So let me know in the comments, what do you guys think about this? And at the end of all my videos, I do the votes because you guys are the jury. So the vote today on this video is, who do you think the judge is going to rule for? Let me get a like if you think the judge is going to rule for Kyle Curtis, and give me a dislike if you think the judge is going to rule for Steve McCrae based on the evidence you've seen. Let's say, hopefully it may be balanced or it may be one way or the other, but I don't know. So let us know down with the likes and dislikes what you guys think. My name is Nate, and we're hoping that when the judge comes out with their verdict, we will definitely be doing a special on that. I got to thank my girl, Holy Spackle. Thank you so much for joining me. Thank you, Headless, for joining me for this full hour. Let me get this last super chat in with Learning with Suge. Great stream. Love the panel. Have a great night. Bye, everybody. Do you guys want to promote anything or say anything? Where can people find you? Let them know something. Let me throw it to Spackle first. Spackle, hit it.
Hi, I'm Holy Spackle, and sometimes I do interviews and I talk to people and stuff, and we talk about life and we talk about the great debate and all sorts of issues connected with that. If you'd like to have an interview, I might like to have a chat with you. And I like to tell people, show me your best self. Not necessarily me personally. You could hate me, but show everybody your best self. And if you don't mind, talking about your beliefs and how you've gotten here on the internet, I love to visit and talk. I'm not all troll. I'm mischievous at times. I can be playful, yes, but in reality, I'm just a real normal person. And I'm not an expert in the law. Obviously, I'm a derp, and I think that's why I sat in this time so I could ask derpy questions to Nate. So thank you so much for letting me sit on the panel, because clearly I'm no lawyer. So
listen, thanks for being here. And what's going on, Headless? Do you want to let the people know where to find you, or are you just good? You just
I'm
around.
Good. I'm good.
Good.
I'm just here to troll people.
I know.
Really.
I know. Well, listen, guys.
Delicious.
This is for the panelists, for everyone. Let me know. Again in the comment sections where we're going to be. Thanks again for all the support. Thank you, Learning with Suge, and all the others Angry Roach, and all the others who super chatted. We really appreciate it, and we're going to be seeing you next time. We'll see what the judge rules. Who knows? But at least it's interesting. Talk to you later.
Good night, everyone, and try not to kiss your dog tonight.
Be excellent to